Well, hi everyone, and welcome to today's webcast. Today we're going to be talking about all things leave related. My name is Kyle Scott. I'm a director at ABLA and joined today for today's webcast with my colleague Jordan Lombardelli. Jordan, good to have you here.
It's good to be here today.
Nice to be able to share some of the heavy lifting as we work through a pretty big topic, to be honest. So before we jump into today's topic around leave, just want to kind of call out the elephant in the room. Many of you watching will be aware that yesterday we had quite a significant piece of reform tabled in Parliament. I think it's described as the Fair Work Amendment Closing Loopholes Bill. So I think we've already put out some publications on that bill. I think that was published on our website overnight. And George, I think we've got we've broken that into three different articles or three different topics.
We've broken into three kind of different key areas, and they're all available on our website now, and also check your emails to access them as well.
Yeah, and so it might be a good time now, if you want to subscribe to receive the information that we put out, you can go onto our website. If you're not subscribed, you can subscribe through that process. But look, it's been a busy year to date, and this is, I think, the third tranche of legislation or reform from the federal Labor government. And I think this one is probably more, I think we all got very excited about the first lot of reforms. I think the bargaining reforms were huge and significant, and they're now in effect. But I think there's some things in this bill tabled yesterday that are quite significant. And I'm thinking, just as an example, the new definition, or the proposed new definition, of casual employment or casual employee.
We've also got the employee-like work that's coming through as well.
That's right. So there's a fair bit to unpack in that bill. I suspect there'll be fairly significant implications for a lot of businesses out there. So I just wanted to call that out before we jumped into our topic. And I understand that in our usual fashion, we'll be rolling out another webcast in the not too distant future that will deal with those reforms. And I suspect they'll be before Parliament for probably 4 weeks before they're made into law. There's likely going to be some negotiation back and forth with various political parties about amendments to that bill. But just calling out the elephant in the room before we jump into today's topic. So today, we're not talking about the reforms, we're talking about leave. I think leave is quite a prescriptive, the rules and the laws around leave I consider to be pretty prescriptive in nature. There's a lot of kind of dense rules around various things. And so today what we're going to do is, some of it will be a little bit of a refresher around the basics of some of the main forms of leave. But there's also been, just to keep us on our toes, there's also been a range of changes to the law effectively, whether it be through the Fair Work Commission issuing decisions to change modern awards. We've had reforms around parental leave. So we're going to do our best in the time that we have to work through the various forms of leave, covering off the basics, focusing our attention on some of those changes. Dealing with the common questions that we tend to see come up from employers. And we've also, we've got capability to take questions live. So if you're watching live, you can plug your questions in and we'll try and deal with as many of those as we can. All right. I think that's a nice little segue to the content. So what we've got here is effectively a nice diagram of all the different forms of leave in terms of, and I'm not saying it's exhaustive, but in terms of the legal minimums and the forms of leave. As you can see, there's quite a number. We'll work through each of the different categories of leave today. And so hopefully that's a nice little diagram to give you a bit of a roadmap as to what we're going to cover. Some quick points. We're dealing with mostly federal laws, but there are some state laws. I'm thinking about long service leave, workers' comp. And so we'll kind of have to bounce around between federal and state law. For things like long service leave and workers' comp, the reality is the law is slightly different from state to state, territory to territory. So we might have to make some generalisations as to what the legal position is, rather than trying to exhaustively cover off the laws in each of the states and territories.
in the short time we have available.
Yes, no, one can dream. So we will focus on those traditional forms of leave, annual leave, personal carers leave, etc. But just bear in mind, and this is probably a reasonably kind of recent development, I think, and I've seen it in particular the last 5 or 6 years, where you get these new and emerging categories of leave. And whether it be some of the major employers looking to be an employer of choice and introducing something through a policy, you also see it from the union movement, quite often at a national level, pushing particular agenda items. And
additional entitlements through bargaining.
That's right.
Yeah.
So we're not talking here about the NES leave categories. We're talking about some of the things that we've seen come onto the radar that probably 10 years ago was very rare. I was involved in a bargaining process for a fairly major employer recently, dealing with one of the unions, and at a national level, that union had a particular priority or a campaign to push gender affirmation leave. And so there are certain unions out there pushing various new forms of leave, if I can use that phrase, through collective bargaining and picking up on the topic of family and domestic violence leave.
Yes.
That is now in the national employment standards, but 10 years ago it wasn't. And effectively, the reason it's now in the NES is because the ACTU pushed for it, firstly, to be included in modern awards.
Yes, it's an unpaid entitlement. It ended up in modern awards.
That's right. And I think they were pushing initially for 10 days of paid domestic violence leave. There's a big hearing, probably around 2017, 2018. The Fair Work Commission wasn't satisfied that they should grant paid leave, but they put unpaid leave into modern awards. That kind of, the snowball effect of there was some momentum in that space. And now we've got 10 days paid family and domestic violence leave in the national employment standards.
And I think one of the big ones that the ACTU is now pushing is that menstrual leave.
Yeah, and so that's an interesting one. People will have different views about that. My view is there might be some cases where that would overlap with personal carers leave if there's a medical condition. But I guess the point of my rambling story about family and domestic violence leave is some of those on the slide there, gender affirmation leave, menstrual leave, possibly kind of ceremonial leave for Aboriginal and Torres Strait Islanders, it's entirely possible that in 5 or 10 years we might have some additional categories of leave in the NES.
And I think the other way that we can look at this as well is that it's not always arising through enterprise bargaining, but also, as you said earlier, employers wanting to be the best business practice. They might be looking to implement things such as your paternity leave, not to be confused with paternity leave. So paternity leave for adoption of pets. There's also study leave, which comes through there. There's also those me days where you just want to have a mental health day. That's also arising through policies with those large employers.
Now, I had to check whether there was a typo in the slide because I'd never heard of pet paternity leave. Interesting one. Not sure whether that will land as in the national employment standards if we're talking about minimum employment standards. But that's right. Like we're dealing with a tight labour market in many cases. And so employers who are trying to compete for talent might quite often be looking as to what additional benefits they might be able to offer. I think a slight word of caution, I'm not trying to be negative about that, but I think if you are looking to do that, there's a difference between putting it in a workplace policy and putting it into an enterprise agreement. It's also different to putting it into an employment contract. So just bear that in mind if you're looking to kind of build some, employer of choice. What do they use in the HR world? EVP, the employee value proposition.
That's the first one for me.
Well, I have a pet, so we could talk about the EVP in terms of providing some, I'm not sure whether you just get to take the dog to the beach or whether it's your dog has to have an illness, I'm not sure. But that'll be interesting to see how that plays out. All right. So we'll work through, I think, a bunch of, possibly all of those leave entitlements. Now, bear with us, some of this will be a refresher for many, but we'll then segue into some of the more kind of quirky, interesting things, topical things, and where the law has changed. So I might take the lead on this slide and I'll let you talk about the next one. So annual leave, and I should give a little bit of a kind of disclaimer or a caveat now that when we talk about some of these forms of leave, I will be talking about it from a national employment standards perspective. So what is the entitlement in the NES? Just bear in mind that if you have an enterprise agreement or even potentially an award or a contract, you might potentially have slight differences. And so to give a really basic example, lots of forms of leave in the NES are paid at the base rate of pay, and that's a defined term in the Fair Work Act. But quite often you'll have an enterprise agreement that might provide the similar entitlement in the sense of 4 weeks of annual leave, but it might specify that it needs to be payable at a higher rate of pay than the base rate. So I'll be talking about predominantly the NES, just putting that disclaimer out there that if you have an EA, even if you deal with modern awards, it's always prudent to go and check the relevant instrument to see what else is in there. So annual leave, most people, and the other caveat I'll put while I'm at it is most of us are employees, whether you're an employer, a manager or an employee, most of us have lived experiences with leave. I think that kind of goes without saying. So most of us will be familiar with what leave entitlements we have, how you take it, some of the rules. So I'll move through that pretty quickly and then we'll get into some of the nitty gritty.
Yes.
All right. So national employment standards, annual leave, the entitlement is to 4 weeks of annual leave or 5 weeks for shift workers. Just bear in mind it's shift workers as per the definition in the award or EA or the Fair Work Act. One kind of trick for new players might be, or tip for new players might be, in modern awards, it's quite common for them to have a stock standard definition of shift worker in the hours of work clause, where it defines someone as a shift worker if they work afternoon shift or whatever. You then go to the annual leave clause further down the instrument and it might have a different definition as to who is a shift worker for the purposes of the additional week's leave. So if we're dealing with award regulated employees and we're trying to work out whether they have 4 weeks or 5 weeks of leave, whether they're a shift worker, quite often the definition is in the annual leave clause of the award, not in the hours of work rostering part of the award, because quite often they'll have different definitions. Yeah. Now, annual leave, same with sick leave or personal carers leave, it accrues progressively. So you don't get it lump sum 20 days or 4 weeks on commencement. It accrues progressively. Annual leave can be taken at times mutually agreed, but the employer cannot unreasonably refuse a leave request. So the upshot of that is employees don't have a God-given right to take leave whenever they want. The employer, it's by agreement with the employer, but as an employer, you can't be unreasonable and refuse leave requests.
So if an employee comes to you, say today, and says, Kyle, I need to take annual leave tomorrow, you might have other people that are off on leave, or it's just not operationally viable for you to do so. In those certain circumstances, you might be able to refuse that request there. But if, say, they give you the 3 months notice, it's a bit difficult then. Yeah,
and there's no specific, unless you've got a policy or an enterprise agreement that says something, and even then it needs to be qualified, there's no mandatory time notice requirement. So you actually, I don't know whether you can have a policy or an EA that says you must give us 2 months notice of any leave request. I think you might be able to have it, but it needs to be qualified, because if an employer can't unreasonably refuse.
Yeah, it goes back to that reasonableness of the request.
And if someone comes to you and says, oh, look, I'm only giving you 3 weeks notice, this is the circumstance, just because it might not be the 2 months notice that you've put in a policy doesn't mean you've got the ability to request, to refuse the request. You just have to consider the reasonableness of it, and that obviously will turn on the circumstances. And sorry, I'll jump back. We'll just consider that, or just a little reminder about that unreasonable refusal in terms of employers refusing leave requests in the context of the recent decision that we'll come to. All right, Jordan, excessive accruals, and when can an employer direct an employee? So we talked about the standard rule, which is employees request to take leave and employers can decline or grant the request, can't unreasonably refuse. What about if you've got an employee who's banking and hoarding their leave What's the situation there for employers?
Yeah, so there's two kind of scenarios that arise. You have your award free and your award covered. So for the moment, we just might focus on the award covered here.
Yep.
So generally, modern awards contain terms about excessive leave accruals and directions to take leave. So what is considered excessive under a modern award is 8 weeks or 10 weeks for a shift work. So it's 8 weeks of accrued leave, which is essentially an employee not taking leave for 2 years.
2 years, yeah.
It's not fantastic when leave is supposed to help them rest and recover. So an employee with 8 weeks of leave is quite a significant amount of leave accrued. When these employees have that leave and you look at your leave balance, you say we need to do something about this, the first thing you need to do is try to reach an agreement with that employee to reduce their leave balance.
Okay. And presumably that's a conversation where you say, Jordan, you haven't taken leave in quite a while. I see that you've got it more than 8 weeks of annual leave accrued or banked, or I think accrued's the right word. Yeah.
Yep.
We want you to take a break. We're worried about fatigue, work health safety potentially, depending on the industry that you're in. So we'd like you to take some leave. Presumably then there's a discussion about the mechanics of when you're going to take it, for how long, etc.
It could be like, I want to have a lovely Euro summer. So I was saving up my leave for that, and you're happy then to go, okay, just book it in so we have it booked in for you. Enjoy your Euro summer there.
Yep. So it might be that they're planning on using it in the not too distant future.
Yes.
What about a scenario where the employee says, no, get stuffed effectively, I'll do what I want, I'm not taking any leave?
Well, the awards are pretty prescriptive in that circumstance there. So after you've had the discussion with the employee to try to get them to take the leave, then you can issue them with the direction to take leave.
Yep.
So what needs to be satisfied is that there's 8 weeks of leave accrued.
Yep.
You're giving them 8 weeks notice at a minimum of when you're telling them to take leave. Your direction can't be less than 1 week.
Okay.
So you have to direct them to take more than 1 week.
Okay. Yep.
And the direction can't result in them at the time having less than 6 weeks accrued.
So if they've got 8 weeks accrued, I wouldn't be able to direct them to take 4 weeks of it.
Unfortunately, no.
Okay, so you just kind of, it's to take the cup analogy, the cup's close to overflowing. We can take a little bit of water out of it, but we can't drain it, and we can't even take it down to halfway.
No, unfortunately not. So it's very prescriptive in those circumstances there.
Okay. And I understand that this is effectively a model term across the award system. So the 120 odd awards, there was a big case, probably now 5 years ago, the annual leave as part of the award review, the common issues matter. And this was effectively a model term. I don't know the answer to this, so I'll put the caveat there that if you're operating under a particular modern award, you should always go and look at the specific award that you're dealing with, because the awards being what they are, there are a bunch of quirks all over the place. And so don't assume that every single modern award has exactly the same clause, because I don't think they would. No,
we've even got a couple of outstanding 2010 awards.
Right.
So,
but that is the model term in the sense that I suspect 80, 90 of the 120 odd modern awards would have the same identical clause. And then we have employees who aren't covered by a modern award. So what's the position there?
So the position is that the direction just must be reasonable.
Okay.
So there's no numbers really in the Fair Work Act as to what the modern awards are, where they say 8 weeks or 10 weeks, but it just must be reasonable. And you're looking at probably somebody with more than 4 weeks accrued.
Yep. And I'm going to put it out there, I would assume that given that the Fair Work Commission has reviewed modern awards, has implemented a model term, that's probably a pretty good yardstick in terms of what might be considered reasonable.
Yes.
Yeah. Okay. Now, annual close down, sometimes called annual shutdown. I don't know whether I think they're interchangeable. I don't think there's a correct term and an incorrect term, but
it might not be correct to say annual either, because it's temporary. Okay. And there's some which happen more often than not throughout the year. Yeah.
So we're talking about temporary shutdown or close down. The typical example is a business will close down for 2 weeks, possibly 3 weeks over the end of year, Christmas, New Year period. And we were talking before about the fact that, going back to the 1950s, I think, not modern awards, but awards have for quite a long time contained clauses allowing for an annual shutdown or a temporary shutdown. They obviously all are slightly different, or they were slightly different and have evolved over the years. But there'll be many businesses out there who will have a practice, possibly have had a practice for the last 30 or 40 years, where they close down for 2 or 3 weeks, at a particular time of the year. Now, modern awards have been around since 2010. They've typically dealt with this. Some of them have allowed it. Some of them have been silent on it. But I understand that there's a fairly significant decision in 2022 that's led to some changes as of 1 May 2023. So what's the story around that?
So it was a long-running case, and I don't know if you remember it, Carl, because it happened for a while and then it just dropped off.
Yeah, and I think the context for it was it came up as an issue in the Black Coal Mining Award as part of the 4-yearly review. And in dealing with the close down provision in that award, the full bench of the commission said, oh, look, this might have some broader implications. And that then triggered a broader look at it.
Yes, that's correct.
And my understanding is effectively the Fair Work Commission has determined that clauses, so where you have employees that have an accrued leave balance, there's typically a right to direct that employee to take their annual leave over the shutdown period. But the probably most significant issue relates to employees who might not have sufficient leave balances for the shutdown period.
And whether that's because they've taken leave throughout the year or they haven't worked long enough with the employer to have accrued that entitlement.
Yep. And so classic example might be a new employee who's been there for a couple of months.
Yep.
And because annual leave accrues progressively, they just don't have that much annual leave accrued. Now, modern awards have, not all of them, but a lot of them have given employers the ability to direct that person to either take paid annual leave or, if they don't have a sufficient balance, to take leave without pay.
Yeah, so a lot of modern awards contained those terms, or they were silent on it, and it was assumed, whether rightly or wrongly, by employers that they had the ability to do so.
Yeah, and presumably if you've got the right to implement a shutdown, you've got the right to tell people don't come to work.
Yes.
And my understanding of the decision that came out, I think August 2022, and it was a split decision. You don't see that often.
No.
So 2 commission members found, in short, that the Fair Work Act did not allow the commission to put terms in modern awards that dealt with directing people to take unpaid leave.
Yeah, that's correct.
Yeah, and so they said, well, because it's unpaid leave, it's actually not about leave at all. It's effectively a stand down.
In certain circumstances, the 524 stand down under the Fair Work Act, it could be, yes.
Yeah, and so we had that majority decision. There was a dissenting judgment from Commissioner Hunt who said, no, I respectfully disagree. But fast forward to 1 May 2023, the awards, I think 70 odd awards were varied. Yes. I suspect the ones that weren't varied potentially don't have shutdown or close down clauses in them at all.
Or they have award specific clauses which are slightly different.
Yep.
But not needing to be updated to the model term.
Yep. And so the effect of these changes is, for employers, if you are a business that has a shutdown, whether it's over the New Year period or over Easter or somewhere else, this creates a real issue, I think. If you've got employees who don't have sufficient leave accrued for that to cover that period of the shutdown, the Fair Work Commission has effectively said, you don't have the right to direct them to take unpaid leave.
Yes.
So what can employers do then?
Well, you could agree to take the leave in advance with the employee, but once again, that's a discussion and agreement with the employee. It's not an automatic right to direct them to take an entitlement that they essentially haven't accrued yet.
Yep. Is there anything else that they can do? I don't know.
So you could try to usefully engage them during that period, but I don't know about you, Carl, but I do like having Christmas off, and I wouldn't want to have to do the cleaning around the office or the filing around the office to make up the time during that period because I don't have enough annual leave accrued.
Yep.
So that's another option. If possible, you could try to usefully engage them for that period. It might not necessarily be the work that they would normally do.
Yep. But I would imagine where businesses close down fully and the business is literally not open, even if you might be able to get someone to do some useful work,
it's not going to cover the whole period.
It might not cover the whole period. There's potentially supervision issues if the boss is overseas for their annual holiday. So you can direct them to take paid annual leave in advance. Oh, sorry, you can't direct them. You can ask them nicely to take paid annual leave in advance.
Yes.
And if there's an agreement, you can do that.
Yes.
So one thing I found interesting as well is the decision doesn't necessarily deal in detail with that agreement in advance, the agreement to take leave in advance. One thing for employers, this might be a possibility, it's untested, but whether an employment contract that has a clause that says the business closes down, for 2 weeks over the New Year period, where you have leave, you'll be directed to take that leave. Where you have insufficient accrued leave to cover that period, you hereby agree
to take leave without pay.
Well, either to take leave without pay or
leave in
advance. So I think that potentially ticks the box of having employee agreement. So that might be something that employers who are kind of sitting there going, wow, this is a significant issue for us. How do we deal with it? That might be a way to deal with it. There might be some absurd outcomes as well. Like if I was a business owner who's closing over Christmas, you might just not employ anyone in December.
Or even further back, you might not employ somebody for the 6 months leading up to December or the 3 months leading up to December.
So you might go, okay, it's October, November, December, we need to hire someone, but we're going to start them in January or February.
Or we're going to have them as a casual to start off with because we're closing down. And because if you don't have the leave accrued, I think this is what you get. The outcome is you pay them not to be there.
Potentially, if you don't get that agreement.
If you don't get that agreement.
Yeah.
The other issue this raises, Kyle, is people generally want to take leave at the times that they want to take leave. And let's go back to this Euro summer example.
Yeah.
If somebody wants to take time off over June or July, as an employee, you might now think, I can't grant that leave because I need you to have a sufficient balance at Christmas because we're having a close down.
Yeah, and so that's a great point, because I wanted to make it before when we talked about employers cannot unreasonably refuse leave requests. Now, because of this development, I think there will be scenarios where an employee in July says, I'd like to take 2 weeks of annual leave. And as an employer, it might now be available to you to say, look, no, we're going to decline that request. We can't grant it, because if we grant that request, the effect is that come Christmas time, you won't actually have enough leave accrual to cover the shutdown period. So that's quite an interesting implication for employees.
But what's also risen out of the second decision was an extra clause being added into the model clause, which said that, we've got it here, it is G, in respect of any part of a temporary shutdown which is not subject to the direction to take the leave, an employer and an employee may agree in writing for the employee to take leave without pay during the period of that shutdown.
Yeah, and so that's probably the most likely sensible compromise solution for employers and employees is, if I don't have enough accrued leave and the business is shutting down, we'll agree for me to take leave without pay. But again, it's an agreement.
Yes.
There can't be any coercion or pressure, because that's probably a breach of the general protections provisions. All right. So I think that we'll call that out as a pretty significant development. It's already in.
Just process rise. You have to give the employee 28 days notice of the shutdown. The direction and requirement to leave must also be reasonable.
Yeah. And so that raises an interesting question around the period of the annual, let's say it's an annual shutdown. If you're an employer that shuts your business down for 3 weeks over the Christmas, let's say over the January period, query whether that length of a shutdown would be reasonable if you're effectively saying to your employees, I require you to take 3/4 of your accrued yearly leave at that point in time when it's school holidays, flights are expensive, everyone else is traveling around. So it might mean that some employers might need to moderate the length of the shutdown period, because quite frankly, we operate 52 weeks of the year, but if my employer said we're having a 3-week close down, I don't think I'd be particularly happy about that, because it doesn't give you a lot of control as to when you can take annual leave throughout the rest of the year. All right, so we'll call that out as a pretty significant thing. It's now September, so if you're dealing with, coming up to the end of the year, dealing with close down, just consider how that might impact you, and potentially consider whether you need some specific advice for your business.
Get those processes in place for the notice as well.
Yeah. All right. So we'll deal with personal carers leave next, and I'll run through this pretty quickly. So from an NES perspective, there's an entitlement to 10 days or 2 weeks of personal carers leave. There's no additional entitlement for shift workers. I'll just call out quickly the fact that it's 10 notional days.
Yes.
And the reason that's interesting and potentially important is there was a decision, the federal court a few years ago, Mondelez, that ultimately went to the High Court. And the federal court initially said the entitlement to 10 days personal carers leave is 10 calendar days. Most payroll systems operate on hours. So it will say a full-time employee working 38 hours a week their payroll system will accrue 76 hours of personal carers leave. It'll be accrued progressively throughout the course of the year. And there was a question, that federal court decision created some complexity where
absurdity
and some absurd outcomes, because it was like, okay, well, our payroll system accrues 76 hours, but depending on what days you take off as personal carers leave, if you're working 10 ordinary hours on some days rather than 7.6, it results in you not actually getting the 10 calendar days. That decision then went to the High Court, and thankfully, I think for employers and thankfully for common sense and just a simple system, the High Court said, no, it's effectively 10 notional days. So we're back to that 76 hours of personal carers leave. So that's helpful. When can you take personal carers leave? When you're not fit yourself for work, or where due to an illness or injury, or where effectively an immediate family member
or member of your household,
if you're in a share house, is sick and requires care or support.
Yes.
The 2 questions that tend to come up, notice and evidence.
I think another good one is people always ask, well, we've had some of them, it's an elective surgery, why should they get personal carers leave when it's elective?
Yeah, and I like those types of questions because I'm quite a technical lawyer at heart. And interestingly, so let's take a dentist appointment. So every year you go and get your teeth checked. You're not unfit for work due to an illness or injury. You don't have an illness, you don't have an injury, hopefully. You just have a medical appointment. Technically speaking, under the NES, you can't take a day of sick leave or 4 hours of sick leave to go to the dentist because it doesn't meet that very strict interpretation of when you can take it.
Possibly even seeing a doctor.
Yeah, potentially seeing a doctor. Well, if you go and see a doctor and they say there's nothing wrong with you, which I don't know how often that happens, but so just bear that in mind. It is interesting, that strict interpretation as to when someone is actually entitled to take sick leave. Now, my experience is most employers are pretty reasonable.
Yeah.
And I know, my boss doesn't ring me up if I'm taking a sick day to go to the dentist.
He might ring you up not knowing
I'm sure he will. He'll ring me up. Yeah, I'll have 3 voicemails. But so what type of notice is required? The employee is required to give the employer notice as soon as reasonably practicable, which could be after the event.
What's your view on enterprise agreements or policies having you must notify us?
So I think
6 hours beforehand or something like that, Kyle.
Yeah, and we see it all the time.
Yeah.
With some slight modification of that wording, I think it's fine. So I don't think you can say you must notify us in advance of the commencement of your shift, or you must notify us and give us at least 6 hours notice. The reason why is because the NES says the obligation is to notify as soon as reasonably practicable, which could be after the commencement of your shift. So soften that language slightly.
Have a reasonableness to the approach.
Yeah, well, look, as a general rule, you should advise your supervisor as soon as you become aware that you won't be able to come to work. We appreciate 2 hours notice or something.
Yeah.
It's just softening that language so it's not a hard and fast rule. It's effectively signalling that this is our expectation, but there will always be cases where that's just not reasonable in those circumstances. The second area is evidence.
Yes.
So this is always an interesting area, and people have different views about it.
And it's quite developing recently with
your
chemists and pharmacists, and also your online telehealth appointments issuing certificates when they might not have seen the person.
So under the Fair Work Act, an employer can ask for evidence that would satisfy a reasonable person that the person is entitled to take the leave. So the Fair Work Act doesn't talk about medical certificates or statutory declarations. It talks about evidence that would satisfy a reasonable person. Jordan, I'll put you on the spot. Medical certificates from a GP, presumably that would satisfy a reasonable person.
Yep.
Quite often people will be unwell. When I'm unwell, I very rarely go to the doctor. I just take a couple of days off to recover. If not a medical certificate, a statutory declaration. What's your view on these pharmacy notes?
I think it's fine in certain circumstances, and once again, we have to look at the individual circumstances of the case. Personally, I wouldn't feel comfortable if it's one for 3 months.
Yeah.
That's probably not reasonable. You might be able to ask for more evidence in that circumstance there. If the person's been using a lot of leave because they have a condition, you might want to find out some more information about that, which the pharmacist or chemist might not be able to give you. But generally, it's accepted evidence.
Yeah, I think my experience, most employers do, as I said, take a reasonable approach. I don't know that any employer has ever asked me to provide a medical certificate in respect of an absence, but I think it does depend on the circumstances. If there's patterns of absenteeism, if we're talking about huge chunks of leave, or they might have exhausted their paid leave entitlement, that would be where I think it's appropriate that the employer delve a little bit deeper as to what's going on.
The other important thing is just look at your policy and industrial instrument, as they might also set out the circumstances in which you can request that evidence. And we see a lot of them where it's quite restrictive, where it's more, you have to have used 5 individual days, 3 of those days have to be in a row, otherwise you can't ask for it. So you do see some clauses like that where it is really restrictive on the amount of information the employer can get from the employee.
Yeah, a really classic one is if you take leave for 2 days or more, or you take leave on a day that sits next to a weekend
or a public holiday,
we've got the right to ask. And I'm not a huge fan of this kind of like, if you take 2 or more days of leave, we can ask. I prefer the NES approach, which is if you want to take sick leave, we've got the right to ask for evidence, and just exercise that discretion reasonably. Pharmacy notes, my view as well, we don't want to be putting this huge burden on GPs, and we don't want to be forcing employees to ring 26 doctors' surgeries to try to get an appointment
that day.
It seems a little bit absurd. Now, paid sick leave for casuals in Victoria. So
not something we ever really say in conversation, no.
No, so this is a bit of a new one, bit left field. It only applies in Victoria. It was born out of the COVID pandemic. What we saw there were people encouraged for good reasons to stay home if they had symptoms. But for casual employees who traditionally don't have paid sick leave entitlements, there was this concern that casual employees were being forced to choose between doing the right thing from a health perspective and staying home versus going to work sick to get paid to pay the rent. And so I think this came out of that kind of COVID era. And the short story effectively is that the Labor government in Victoria have implemented a 3-year pilot trial. It only applies
certain industries.
So not every industry, and I think it's administered through Service Victoria. So it's effectively kind of almost like that social welfare benefits system.
Interestingly, they also have it at 38 hours. It's not referred to as a week payment. It's referred to as a 38-hour payment.
Yeah, okay. And it's paid at the minimum wage, but effectively, if you're an eligible casual in Victoria who doesn't have, casuals aren't entitled to paid sick leave. If you're in Victoria and you're eligible in the sense that you're in a particular industry and you're sick, you can access this government benefit. It's fully funded by the government. It's not payable or paid by employers. I think it's between March 2022 and March 2025. I think there's an error in the slides. I think it's
2 years. It's 3 years.
3. And presumably what we'll see at the end of that trial is there'll be a report. It'll presumably make some observations about how, what the usage was and whether or not that kind of creates some momentum towards some form of new entitlement potentially. I think for lots of employers out there, they would say...
as long as the government pays for it?
Well, I think they would say sick leave for casuals, the reason they don't get sick leave is they get the 25% loading. And so if they're suddenly going to get this paid sick leave entitlement, let's wind back the 25% loading. And it's hard to disagree with that in terms of the rationale for the system that we have. Compassionate leave. We might move through a few things pretty quickly because I've probably spoken too much.
I can
so
speak
do you want to deal
about
with this?
compassionate leave. So generally it's 2 days per permissible occasion.
Yep.
So it's a non-accruing type of leave. So you don't get 2 days and you can only use it once per year, or you don't get 4 days the year after. It's an access as needs type of leave.
Yep.
So it's used for generally after the death of a family member or someone of the household. A recent addition is about the stillborn child. So that's come about as some parental leave changes as well.
Yep.
Or if the employee or the employee's spouse or de facto partner has a miscarriage.
Yep.
So we're looking at generally people might access it for funerals or when one of their loved ones is nearing the end of their life.
Yeah, and so I think the phrase immediate family member is specifically defined in the Fair Work Act.
Yes.
So just bear that in mind. I think employers, in my experience, I haven't seen any, exclusions.
I've never seen somebody refuse compassionate leave to go attend a funeral.
Yeah, and
regardless of it's the immediate family member, if it's a uncle's wife or something. Yeah.
And I've also seen in the last kind of 5 years, unions have been quite good around pushing this as a agenda item as bargaining or as part of their log of claims, seeking 3 days compassionate leave or 4 days compassionate leave. And I've seen some employers kind of agree to enhance compassionate leave, sometimes subject to kind of, it might say where, there's travel of more than 300 kilometres, you get a third day or something like that. So it's an interesting area around how that entitlement will evolve. Now, I might have covered some of this in the intro, but family and domestic violence leave, as I said, I kind of talked through the development of that, which I think we have on the left-hand side of that slide around the chronology. But this is the newest form of entitlement in the National Employment Standards. It's got some differences compared to the annual leave, personal carers leave in terms of how it operates.
Yes.
We can probably just rattle off the key differences now.
So you've got 10 days paid leave for casual employees as well that would have been rostered.
Yep, and so I think this is the only leave entitlement in the NES that casual employees are eligible to paid leave.
Yes.
Yeah. Okay, so one of the main differences is this is a paid leave entitlement for casuals as well as permanent staff. 10 days, so that's not hugely different to personal or carers leave. It doesn't accrue progressively throughout the year like annual leave and personal carers leave, and even something like long service leave arguably accrues as you obtain your service. This is, you get it on commencement date, you get 10 days, but it's a use it or lose it, so to speak, in the sense that it doesn't accrue progressively, but equally it doesn't accumulate.
That's correct. So just for small employers, for example, they would have got it from the 1st of August, and then the next year their employees would get it again on the anniversary date.
That's right, but you can't get to 2027 and have employees with a balance of 37 days of domestic violence leave. So it resets back to zero on each anniversary. I talked about annual leave and personal carers leave under the NES at least being payable at the base rate of pay. Just bear in mind, family and domestic violence leave is paid at the full rate of pay. So it's paid at the higher rate. That, again, I think is defined.
Yes,
it's
so it can include shift allowances. I think even in some circumstances, if it's rostered overtime, it would also include the rostered overtime there. But you just have a look when you're paying it out. Essentially, a good way to think about it is it's what your employee would have been paid had they worked. Yep,
absolutely. The circumstances in which this leave entitlement can be accessed is often a question we get. I think the NES talks about an employee who needs to take leave to deal with the impacts of family and domestic violence that they're experiencing. So you're talking about leave to deal with the impacts. So that might involve moving house. So
court dates,
going to the police station if there's some kind of criminal process on foot, medical appointments, counselling, or effectively organising your life, going to the bank to potentially get a new bank account or something like that, that's obviously not exhaustive. So just bear in mind, if this comes up, we're talking about, okay, well, does the person need to take time away from work to deal with the impacts of the experience or the violence that they're dealing with, not experience violence?
Yeah. The final thing to note there is, as of June 2023, you can't record family domestic violence leave on payslips. Before June and from its introduction in February, you could have had it as special leave.
Yeah.
I wasn't a huge fan of that because the whole purpose is to help the person in a family domestic violence leave situation. So now the payslip should just look like what a normal payslip should had they worked.
And that's another key difference, I guess, from a compliance perspective, because the Fair Work Act and the Fair Work regulations have these quite prescriptive rules around keeping employee records and the content on payslips. So typically you need to keep all these records and you have to have your payslip
shows the accrued balance,
accruals. This is not the case here. There's some special rules around you're specifically not permitted to have this on the payslip.
You still need to have it recorded somewhere. The Fair Work regulations do require that. You just can't show it when the employee takes the leave on their payslips.
Yep. So just bear that in mind, particularly if you're in the payroll team, the special rules around that entitlement. Community service leave. It's been in the NES for more than a decade since the Fair Work Act came out. I don't see this coming up all that often, but do you want to deal with that quickly?
We saw it a fair bit in the bushfires though, about 2 or 3 years ago in 2019. We might see it a bit with the current weather that were happening and what they think this summer is going to be like. But essentially, it's not a set amount of leave like our other types. So it's not you get 10 days to attend voluntary emergency management activity. It's an as-needed entitlement.
And we're talking about employees who are members of the Rural Fire Service, for example, the SES, State Emergency Service, Defence Force Reserves.
Slightly different, but generally covered by this as well. There's another act that covers Defence Force Reservists as well.
And then we also have jury duty. So in short, I think if an employee is required to be on jury duty, what do they get paid? They get make-up pay.
They generally get make-up pay. It's also state by state. There's some slight differences. Once again, it comes from a jury duty act as well, but they generally get make-up pay for the first 10 days that they're required to be on jury duty for. They need to provide evidence though.
And I mean, that's quite interesting because sometimes criminal trials might go for 6 weeks or 8 weeks and the unfortunate employee might be on jury duty, which is a very important civic duty, but potentially unfortunate in the sense that after that 10 days of make-up pay, they're potentially suffering a drop in their income until they get back to work.
Yeah, that's correct.
Parental leave. So this is the next area where we've had some fairly significant reforms. So
they kind of just passed through without a whole heap of discussion or...
I think that's right. I don't think they were overly controversial from a political perspective. So this was a separate bill that passed through the federal parliament. If I set the scene, under the NES, employees have an entitlement to 12 months of unpaid parental leave. Eligible employees, so you have to have had 12 months service as at the date of leave or the expected date of birth, which is
the change that's been brought in as well.
And you then always had the right to request an additional 12 months of unpaid parental leave. That leave could only be refused on reasonable business grounds. Casual employees also had an entitlement if they'd been there for 12 months and worked regular and systematic with a reasonable expectation, that kind of traditional test. So we might just move on to the next slide and deal with the changes. Do you want to deal with those?
Yeah, so there's been some quite significant changes which have also arisen out of changes to the Paid Parental Leave Act. So the Fair Work Act has also been changed to kind of mirror and adopt to those terms that have been changed in the Paid Parental Leave Act. So some of them are both parents have the entitlement to 12 months. So before we had terms in the Fair Work Act about certain couples, their partner's parental leave would impact the other partner's parental leave balance. So it was essentially 52 weeks for both of them. That's now been done with. So each parent gets 52 weeks. They can take it at the same time whereas previously it was only 8 weeks concurrently.
Yeah, so the NES talked about concurrent leave, but they said parents could take leave concurrently, but only for an 8-week period.
Yes.
And so they've done away with that requirement. So potentially it sounds like both parents, let's say both working parents with an entitlement, they're eligible under the NES. Scenario one might be they both choose to take 52 weeks of parental leave together at the same time. Yep. Scenario two might be parent A takes 12 months unpaid parental leave, and then at the end of that 12-month period, parent two takes full 12 months, so they get 2 years of coverage for care of the child, and they're both taking 12 months each.
Yes.
Okay. What else? So we've got these flexible parental leave days.
Yes. So in about 2019, flexible parental leave days was introduced.
Yep.
It was a 30-day entitlement.
Yep.
It's now been moved up to a 100-day entitlement. So essentially it allows the employee to take a period of their parental leave flexibly.
Yep. So
it's been changed so they can take some of those 100 days up to 6 weeks before the birth of the child.
Yep. Or
you can take it during a parental leave period.
Yep. And I think it's any time during that 24-month period. So, my brain hurts doing maths, but it might be, let's say someone takes 9 months. Let's say they say, I'm going to take 12 months of parental leave. I'm going to take the first 9 months in a block. And then the last 3 months, so 93 odd days or thereabouts, those last 3 months, I'm going to take them 2 days a week for 45 weeks. It's roughly 90 days.
Your maths might be better than mine.
So you've got a 9-month block, and then you've got, 45 weeks of parental leave on a 2-day-a-week basis. I think that would be contemplated, and that's permissible under the NES now. So I think the upshot for employers trying to deal with that and manage that, and I think there's good reasons for these changes. I read something the other day talking about workforce participation with females, and it's actually working females is now exceeded the level pre-COVID. And so we're in a world where there's quite often families where both parents are working, the female participation rate in the workplace is at record high. So these are really important reforms to assist in that space. On the counter side to that, you've then got supervisors, managers, employers having to effectively just deal with that operationally.
When they might have filled the role with a full-time person.
Yep.
For the 9 months, your employee gives you, let's say within that 9-month period, 4 weeks notice, which they're required to do about taking some flexible parental leave days.
Yep.
Then you need to deal with the employee who's currently filling in.
Yep.
And having those conversations with them as to, are you happy to stay on and continue working?
Yeah, and so I think
on a part-time basis whilst this person comes back in.
Yeah, and that traditional notion of, okay, we need a mat leave cover, and we shouldn't even say mat leave anymore. I think we should say parental leave cover.
Parental leave.
But the traditional thing was someone's going on parental leave for 9 months or 12 months or whatever it is. We'll put an ad up. We'll get someone as a temp cover for that period, and it might be full-time.
Yep. And
then it's a fixed term arrangement, and then it ends. This slightly makes that a little bit more complex in the sense that you've got this potentially lagging flexible use of parental leave. And so employers will just have to grapple with, how do we deal with that operationally?
Yeah.
On one view, it's not that different to someone who was full-time going on parental leave and then returning 2 or 3 days a week.
On a flexible working arrangement,
Yeah, that's very common these days. So it might not be that different, but probably the key point is there's no reasonable business ground for refusing this type of arrangement. So it is a right. They can take 100 days flexibly. An employer, no matter how inconvenient that might be for your production or your operations, you can't decline that request. It's a right. But there are some notice requirements, yeah?
Yes. And it's a good time to review your parental leave policy with these changes that have come into effect now.
Yep.
Because we see a lot of them reflect the terms of the National Employment Standards. So a lot of them have the use of employee couple or concurrent leave or dad and partner pay, which have all been done with.
That's right. So if you have an existing parental leave policy, as at 1 July, it's probably no longer correct. It's no longer compliant with the NES. You'll need to update that. You might also even have enterprise agreement terms that are now effectively unlawful and of no effect because they cut across the NES. So just bear that in mind. But absolutely, I suspect just about every employer out there with a parental leave policy needs to be redoing it.
Yeah. Public holidays is our last big one.
Yeah, I'm interested. I've found this interesting because lots of people will be aware, but
and I don't think people think public holidays leave.
So, well, whether it's a type of leave or not, I think it's a right to be absent for work without loss of pay for permanent employees. But the federal court, always very sympathetic to the not out of touch at all, dropped their decision. So there was a federal court decision mere weeks before the Easter long weekend earlier in the year. It arose out of a dispute, but what we have, and the federal court decision effectively is just telling us what the law has always been under the Fair Work Act. Under the NES, correct me if I'm wrong, but it has this almost faulty towers process to it where it says an employer can request an employee to work a public holiday. The employee can refuse that request if the request is unreasonable. But then the employer can direct the employee to work if their refusal is unreasonable.
Yes.
And so
it's about jumping through those hoops.
And so pre this decision, typically what employers would do is they'd say, you need to work a public holiday because it's in your contract or it's the nature of the industry. I'm giving you plenty of notice. Quite often your remuneration is set having regard to the fact that you need to work the public holiday. Quite often you'll see loaded rates and these have been built into the annualised salaries. And the employer would roster the person or the employer would just say, you need to work.
Yeah. And when the employee said, I don't want to work it, they would say, too bad, so sad.
Tough luck.
Yeah.
So I don't actually think that this decision means that there's some material change. In most cases, there won't be a huge change in outcome. The change is this ridiculous process, in my opinion.
Yes.
And look, this isn't a criticism of the federal court because they're simply telling us what's in the NES. Rather than simply directing, we have to ask employees nicely to work the public holiday. If they agree, happy days. If they say, no, I don't want to, we would then write them a letter saying, I note that you've refused or you've declined my request for you to work. I'm now hereby directing you to work.
Yes.
And I set out the reasons why. And the Fair Work Act sets out some reasons. I think it's section 114 off the top of my head.
Yes, 114.4.
And in terms of what's reasonable, I think if you're looking at employment contracts, now might be the time to have something in your template contract that talks about if there's a culture or practice within your business where you do need people to work public holidays, it's nice to have something set in stone in the contract so that employees, prior to even starting work with you, have a clause in the contract that says it's a requirement or it's an expectation as part of your role that you'll work public holidays.
It doesn't replace the request though.
That's right.
But it helps with the request.
It helps with your subsequent direction being reasonable.
Yes.
If their REM is set, having regard to that, call that out. And then I think it's just that procedure whereby if we do need to direct, we need to tell them.
Yes.
Putting them on, and sorry, I probably ignored this slide entirely.
Yes.
And we're actually talking about the next slide. But publishing a roster does not constitute a request. That was specifically called out by the federal court. So you just need to effectively build this into your procedures around how you deal with public holidays.
Set yourself an alert a month before the public holiday to start that process of writing the request so you are prepared for the public holiday.
That's right. And now, last thing to say is it's currently being challenged in the High Court.
Yes.
They're seeking special leave. So it may be another Mondelez where it's ultimately overturned by the High Court. We'll have to wait and see. I won't express a view about that because
currently the state of the law is requesting.
That's right. That's right. Long service leave. So this is one that's, and I think we then talk about workers' comp.
Yeah, only a little bit more.
Yeah, so for both of these, it's hard for us to generalise because the law is slightly different from state to state. But most people are familiar with long service leave. In New South Wales, as an example, it's 2 months of long service leave after 10 years and an additional third month after 15 years. Different states are slightly different. Quite often there'll be rules around pro rata payment of leave in certain circumstances.
When you can actually take the leave, can you take it in 1 day periods, so it has to be a month period? that's all set out in each different legislation.
Yep, and then to add a little bit of complexity, you then have some portable long service leave schemes in various industries. So just bear that in mind as well. We don't have time to deal with long service leave in any detail, but just bear in mind, state to state, it can be different. And that's the same for workers' comp, really.
Yes. I think that just the call out for workers' comp here is that each state or territory's jurisdiction may say if you can accrue annual leave or paid leave or take annual leave or pay personal leave throughout it. So just be careful about that and looking at the specific legislation. And with workers' compensation and long service leave, if you're a member of the New South Wales Business Chamber, we have the Workplace Advice Unit who are extremely experienced in these matters, and just give them a call on 132959.
Yeah, lovely. All right. Well, I think we've run perfectly at a time, which is rare.
We didn't get too many questions, unfortunately, but hopefully we've covered off your burning queries. So
yeah, and I suspect we would have dealt with a lot of people's questions as we went through that material. But as we said before, parental leave policy, if you're not looking at updating that, that's probably that needs to go on your to-do list. Dealing with public holidays, dealing with annual close down, these are the types of things that you should be thinking about now. Reach out if we can help further. As I said at the start, we'll have another webcast in the not too distant future.
I think it's on the 14th of September, but the invites will be going out shortly for that.
Okay, so just keep on the lookout for being able to register for the next webcast that'll deal with that third tranche of reforms. Other than that, I think we'll say bye and thanks for joining in.
Thank you.